At exactly 6 a.m. on Tuesday, while most of Washington was still sleeping and the network news crews were just pouring their first cup of coffee, a document was filed in the D.C. Circuit Court that didn't just reject a motion. It effectively rewrote the rules of the American presidency. There were no cameras in the room. There was no oral announcement, just an electronic notification that hit the docket before the sun came up. The ruling came from a panel of 3 judges: Florence Pan, a Biden appointee; J. Michelle Childs, another Biden pick; and Karen LaCraft Henderson, appointed by George H.W. Bush. The media immediately seized on the word unanimous. They want you to believe this is a bipartisan slam dunk because a Republican appointee signed on to it. But when you look closer at the 57-page opinion, you see something unusual. It was issued per curiam. That means by the court as a whole, unsigned by any individual judge. They presented a unified front to strip away executive immunity, claiming that a former president has no more protection from prosecution than any other citizen. The establishment press is framing this as a victory for the rule of law. They are running victory laps, telling you that justice is finally being served against Donald Trump. But something even more significant is happening that the establishment doesn't want you to see, and it's happening in the silence coming from the Supreme Court building across the street. While the D.C. Circuit was working overtime to get this opinion out before breakfast, the Supreme Court has been conspicuously quiet on the docket management, and that silence is deafening. The timing of this 6 a.m. release wasn't an accident. It was a calculated opening move in a constitutional chess match that threatens the separation of powers for generations to come. But while everyone is focused on the timestamp, they are missing the trap door buried inside the text itself. I've read the full 57 pages, so you don't have to, and what's buried on page 32 is chilling. The court didn't just rule against Donald Trump on the specific facts of January 6th. They went much further. The judges explicitly wrote that former President Trump has become Citizen Trump with all of the defenses of any other criminal defendant. On the surface, that sounds like equal justice. But here is the problem the media refuses to discuss. The presidency is not a normal job, and the Constitution created a unique structure to protect the executive branch from being paralyzed by the judicial branch. Before we go any further, hit that subscribe button. Join this community, because what I'm about to share is something the mainstream media won't tell you, and you need to be part of this conversation. The ruling relies heavily on the idea that once a president leaves office, the separation of powers doctrine effectively evaporates regarding criminal prosecution. This opinion asserts that federal courts have the power to review, judge, and imprison a former commander-in-chief for official acts taken while in the White House. The judges dismissed the concern that this would open a floodgate of politically motivated prosecutions, calling that fear unsupported by history. That is a stunning statement. It ignores the reality of the weaponized legal warfare we are seeing right now. This isn't just about Donald Trump. This is where the plot twist happens. If this precedent stands, it creates a blueprint for destroying any future conservative president. Think about what that precedent does to a President DeSantis or a President Vance in 2030. Every executive order on the border, every decisive action on foreign policy could be criminalized by a hostile successor's Department of Justice. The panel cited Marbury v. Madison to claim the judiciary has the final say, but they conveniently sidestepped the core constitutional crisis. Can a president function if he knows his political opponents can throw him in jail the moment he leaves 1600 Pennsylvania Avenue? This ruling says yes. It creates a paralyzed executive, terrified to act, constantly looking over his shoulder at the next prosecutor. But while everyone is reading these 57 pages and debating the legal theory, they are missing the trap door that special counsel Jack Smith just opened with the calendar. When you connect the 6 a.m. release time with the February 12th deadline imposed by the lower court, the picture becomes clear. This isn't just a legal ruling, it is a scheduling weapon. The 3-judge panel gave President Trump an incredibly tight window until February 12th to file an appeal with the Supreme Court. If he doesn't file by then, the stay lifting the trial proceedings expires, and Judge Tanya Chutkan can immediately restart the clock on the trial. This is a pincer movement. One arm is the special counsel pushing for speed at all costs. The other arm is a lower court setting impossible deadlines. The goal isn't justice. The goal is the calendar. They need this trial to happen before November. They know that if the Supreme Court takes the case through the normal process, granting what's called certiorari, hearing oral arguments and issuing a thoughtful opinion, it could take months. That pushes the trial past the election. So the D.C. Circuit has rigged the timeline to force the Supreme Court's hand. By issuing the mandate so quickly and setting the stay to expire in days, they are daring the Supreme Court to intervene. They are trying to make the justices look political if they slow down the process to actually read the briefs. It is a pressure campaign designed to rush the highest court in the land. Jack Smith cited the public interest in a speedy trial, but he never mentions the public interest in a fair election free from judicial interference. In 1974, during the Nixon tapes case, the Supreme Court moved quickly, but the stakes were different. There wasn't an election a few months away involving the leading candidate. Here, the timeline is the entire strategy. The silence from the Supreme Court up until now suggests they have been waiting for this lower court ruling, but now the clock is ticking on them, too. The D.C. Circuit has effectively placed a ticking time bomb on Chief Justice Roberts' desk. What we are witnessing is the criminalization of the executive branch. If this ruling stands, no president, Republican or Democrat, can govern without fear of jail time from a hostile successor. We are watching the transformation of the American legal system into a tool for political liquidation. The establishment is betting that the American people will be too distracted by the headlines to notice that the constitutional separation of powers is being dismantled in real time. But this isn't over. The Supreme Court remains the final firewall. The justices have a duty to the Constitution, not to Jack Smith's election calendar. This is where you come in. We cannot fall into despair or apathy. That is exactly what the Washington establishment wants. They want you to feel like the outcome is predetermined. It is not. First, you need to stay informed on the specific motions filed in the next week. Watch the docket. Second, contact your representatives and demand they hold hearings on the Department of Justice's funding and its interference in the election timeline. Third, support the legal defense funds that are fighting these battles on the front lines. And fourth, use your voice to educate your neighbors. Tell them this isn't about one man, it's about the office of the presidency. The walls may be closing in, but the Constitution was built to withstand siege. It has survived civil wars, world wars, and political corruption before. It just requires us to man the ramparts. We don't just watch history happen, we shape it with our vigilance. Stay strong, stay engaged, and keep your faith in this republic.